Child Support Law number 4 in this 10-part series, the Child Support Recovery Act of 1992, is where child support enforcement crossed new lines, literally. This is the law that made failure to pay across state lines a federal crime. Not a civil dispute, not a local issue, a federal offense. If you missed the first 3 child support videos on Title 4D of 1975, the Bradley Amendment of 1986, and the Family Support Act of 1988, be sure to go back and watch those for more context, and I'll put links for those in a pinned comment as well. After automating child support through the Family Support Act in 1988, Congress wanted a way to chase fathers who moved or relocated to a different state for work. So they created a federal crime especially for interstate non-payment, something that had never existed before. So today I'm going to show how this law turned child support into a federal jurisdiction issue, how it expanded government power beyond the state courts, and it laid the groundwork for even harsher laws that followed later in the 1990s. The Child Support Recovery Act was signed by President George H.W. Bush in 1992. By 1992, the child support system already had a lot of systems and punishments in place. Title 4D created the funding initiative. The Bradley Amendment made the debt permanent, and the Family Support Act automated the collection machinery. The next step was simple: expand the reach of enforcement beyond state borders. That's where the Child Support Recovery Act comes in. States had always struggled to enforce support orders when fathers moved, whether for work, cost of living, maybe a new relationship, or a fresh start after a divorce. Crossing the state line did not erase child support obligations, but it made enforcement slower and more complicated. The government framed this as evasion, even though relocation is a normal part of adult life and employment. Hell, I've lived in 4 different states in the past 10 years, each of them because of employment changes. But Congress saw it as an opportunity to expand enforcement authority, and they did it through criminal law. So the Child Support Recovery Act made it a federal crime to not pay child support to a child that lives in another state. It didn't matter whether a father moved for work, because he couldn't find a job in his local community, or because he was priced out of his hometown after a divorce. If he crossed the state line and fell behind, the United States Department of Justice could, and they do, go after him. Federal prosecutors were suddenly involved in what had always been reserved for civil family court matters. The law's messaging focused heavily on the deadbeat dad narrative, the same political framing that shaped the Bradley Amendment 6 years prior. Media at the time painted fathers who moved as intentionally abandoning their families, even though the majority of interstate relocations had nothing to do with avoiding support. Economic restructuring in the 1980s and early 1990s meant millions of men had to move for work, especially manufacturing workers displaced by plant closures. But instead of recognizing this economic reality, Congress criminalized their movement when child support was involved. As always, for mothers, the law was framed as protection. Again, a guarantee that fathers could not escape obligations by moving to another state. And as you would expect, for children, it was presented again as ensuring continuity of payment. But for fathers, it added just another layer of pressure. Moving for work could now trigger federal involvement if support fell behind. So a missed payment wasn't just a debt, it was a criminal exposure with potential jail time in the balance. So listen, if you're new here, I'm Todd. I'm a psychologist and author who supports men in life and in relationships, and I expose many of the larger issues that men face today. If this is the kind of deep content that you want more of, be sure to subscribe. Let's see if we can get to 1,000 subscribers by the end of the year and help get these messages to more men who need them. So the enforcement mechanism looks like this. A father owes money and lives in a different state than the child. The Department of Justice can file federal charges. Penalties can include fines, probation, and up to 6 months in a federal prison. Maybe a state prison, I'm not sure, but 6 months in prison. And because the Bradley Amendment, as I discussed in a previous video, made arrears permanent, going to jail did not erase the debt. It kept growing and accruing, including new fines and interest along the way. So now, the Child Support Recovery Act turned child support from a state-based civil obligation to a federal criminal matter anytime a state border was crossed. It fundamentally changed the nature of enforcement by expanding government authority instead of addressing the economic instability that often caused non-payment in the first place. And I'm sure you're starting to really see the vicious cycle at this point. So the Child Support Recovery Act didn't discriminate between fathers who refused to pay and those who were simply unable to. The law treated both the same. They're all criminals. And the long-term impact was enormous and still is. Federal jurisdiction makes child support enforcement national instead of local. It sets the stage then for the Deadbeat Parents Punishment Act of 1998, which I'll cover later in this series, and intensified penalties and added multi-year prison sentences. Altogether, these laws created a system whereby failing to pay child support, even for reasons outside of a father's control, became one of the most aggressively prosecuted financial obligations in America. In short, the Child Support Recovery Act of 1992 transformed child support non-payment into a federal crime, expanded enforcement across state lines, and tightened the net around fathers who are already struggling under the financial weight of earlier laws. And this was only the beginning of interstate criminalization. As in the next video in this series, we'll learn about the Full Faith and Credit for Child Support Orders Act, that's a long one, of 1994. So let me know your thoughts and your experience with interstate and federal issues regarding child support, and be sure to come back soon, because next I'll expose the 5th of 10 laws in this series and how federal extensions continue to add more authority to the states themselves.